Well, I'm glad to have you join me for another session of History by Lou. Today, we're taking a look at the Supreme Court and the rulings that it's made over the last 248 years. It has made some good ones and it has made some bad ones. So as you listen to this presentation today, I want you to ask yourself three questions. The first one is, what were the three worst rulings of the U.S. Supreme Court? And there have been some real humdingers. And secondly, what were the three best rulings? And there are some that are really marvelous, that really have helped our Constitution and our society. And finally, in recent years especially, has the court become too partisan, too political? And if so, what do you propose we might be able to do about it? So anyway, that's the topic. Those are the questions. Let's get underway. What we're going to do today is to take a look at the Supreme Court in action. We're going to look at some of the very good rulings that there have been from the Supreme Court over our 248 years of history, and some of the very bad ones. What you hear is the gavel of a judge in a courtroom in the United States. And I hope if you're ever in a courtroom, you're on the right side of the law, because in America, as difficult as things may be, we do operate under the rule of law. So what were some of the influential cases? The first one that's usually mentioned is Marbury versus Madison in 1803. Now, when the founding fathers met in Philadelphia in that long, hot summer of 1787, they spent most of their time trying to figure out what Congress should do. They then gave the presidency also only light attention because they sort of concluded without saying so that probably George Washington would be the first president and he would establish what the office was going to be. They also spent very little time on the Supreme Court or the court system. And so when they adjourned, then it was left to the Congress in 1791 to come up with how the Supreme Court is structured and the inferior courts and how they operated. John Jay was the first Chief Justice, and he really didn't even enjoy being Chief Justice. It wasn't until we get to John Marshall, who is a newly appointed Supreme Court Chief Justice, and he has a ruling in 1803 that's groundbreaking. It establishes the principle of judicial review. A law repugnant to the Constitution is void, he said. With these words, Chief Justice John Marshall established the Supreme Court's role in the new government. Hereafter, the court was recognized as having the power to review all acts of Congress where constitutionality was at issue and judge whether they abide by the Constitution. And that was a good ruling because it set the precedent for everything that was to follow. Another important ruling was McCulloch versus Maryland in 1819. He said, "Let the end be legitimate, and all means which are consistent with the letter and spirit of the Constitution are constitutional." Chief Justice Marshall invoked this phrase to establish the right of Congress to pass laws that are necessary and proper to conduct the business of the U.S. government. When they wrote the Constitution in 1787, one of the clauses, clause number 18, reads that Congress has the legislative power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution and the government of the United States or any department or officer thereof. See, in 1787, there were no televisions, there was no internet, there were no airplanes, there were no trains, there was none of what was to come later. But they knew that there would be different things coming, and so they wrote the necessary and proper clause to allow for new things to be included in our definitions. In McCulloch versus Maryland, the court upheld Congress's power to create a national bank in that case. Another good ruling on the part of the Supreme Court. Gibbons versus Ogden in 1824. When a federal and state law are in conflict, the federal law is supreme. Congress and New York had both passed laws regulating the steamboat industry. Gibbons had a federal permit for a steamboat business. Ogden had a state permit for the same waters. Siding with Gibbons, the court said that in matters of interstate commerce, supremacy clause tilts the balance of power in favor of federal legislation. Another good ruling on the part of the Supreme Court. Andrew Jackson, however, did not enforce the Supreme Court ruling in 1832. Andrew Jackson, the seventh president, defied the Supreme Court's ruling in Worcester versus Georgia. In 1832, the court ruled that the state of Georgia did not have the authority to regulate the Cherokee Nation, which was a sovereign nation within the United States. Despite this ruling, Jackson refused to enforce the decision, stating that John Marshall has made his decision, now let him enforce it. This quote, although disputed, reflects Jackson's reluctance to challenge the state of Georgia and his support for the forced removal of Cherokee Nation from their ancestral homes. Jackson's administration did not take any action to enforce the Supreme Court's decision, and the Cherokee Nation was eventually forced to relocate to Indian Territory, which is now Oklahoma, in 1838. That event, known as the Trail of Tears, resulted in the deaths of thousands of Cherokee people. You see, it's interesting to remember that the Supreme Court has no army. It has no police force. It has no FBI. And so when it does make a ruling, it is dependent upon the administration, the other one-third body of our national government structure, to enforce whatever they say. For the most part, that has happened. But here is one important case where it did not happen. And so this was a very bad decision on the part of the Andrew Jackson in particular, but it was a bad, sad tale to tell. Charles River Bridge in 1837. The responsibility of the government is to, quote, sacredly guard, unquote, the rights of property for the prosperity of the community. The Charles River Bridge was erected in 1785 by Harvard College and some prominent Bostonians under a legal charter granted by the state of Massachusetts. The legislature granted a charter to the Warren Bridge Company in 1828 because a new bridge was badly needed. It was to be free of tolls once construction costs were covered. The proprietors of the Charles River Bridge were afraid that the new bridge would destroy the value of their stock, and they tried to block the construction of the Warren Bridge. This was a good ruling on the part of the Supreme Court. The case involved a conflict between established rights on one side and the rights of the community on the other. The court ruled that it had not entered into a binding contract with the Charles River Bridge Company that would prohibit the building of a competitive bridge. Justice Roger B. Taney stated that the rights of property must be sacredly guarded. The community also has rights, and the responsibility of all government is to promote the happiness and prosperity of the community. A good decision on the part of the Supreme Court. Then we come to Dred Scott versus Sanford in 1857. The Constitution does not consider slaves to be U.S. citizens. Rather, they are constitutionally protected property of their master. Chief Justice Roger Taney authored this opinion, one of the most important and scorned in the nation's history. Dred Scott, a slave, had moved with his master to Illinois, a free state. He moved again to a slave state, Missouri, and filed suit to gain freedom under that state's law of once free, always free. Taney held that Scott had never been free at all and cited constitutional grounds for placing the slavery decision in the hands of the states. In trying to put an end to the slavery controversy, Taney instead sped the nation toward the Civil War. The decision was later overturned by the 13th Amendment and the 14th Amendment, which says that people are citizens and are real people. And this undoubtedly can be classified as the very worst decision of the Supreme Court. And what's a bit of irony in this is that generally Taney was a decent Chief Justice. But in this one case, he really basically ruined his entire reputation for history. A very bad decision. Oh, the worst. There may be disagreement about the other worst ever Supreme Court cases, but nobody disagrees that this one is hands down the worst Supreme Court decision ever. Dred Scott held that African Americans, whether free men or slaves, could not be considered American citizens. The ruling, unfortunately, also undid the Missouri Compromise, barring laws that would free slaves and all but guaranteed that there would be no political solution to slavery. And so we have to fight a civil war in which 700 or so thousand people give their lives. The opinion even included a ridiculous parade of horribles that would appear if Scott were recognized as a citizen. Unspeakable scenarios like African Americans being able to vacation, imagine that, hold public meetings, oh, incredible, or exercise their free speech rights. The 13th and 14th Amendments to the Constitution overturned the 1857 Supreme Court decision in Dred Scott versus Sanford. The 13th Amendment outlawed slavery, and the 14th Amendment granted citizenship to all people born in the United States. Bad, bad, bad decision. Versus Illinois, 1877. Businesses that serve the public interest are subject to regulation by state government. The Illinois state legislature passed a law that established the maximum rates for private companies could charge for storing and transporting agricultural products. In Chicago, the company of Munn and Scott was found guilty of breaking the law, and the verdict was upheld unappealed before the Supreme Court. The court ruled that any business that served the public interest was subject to regulation by the state government. If the rates were not satisfactory according to the owners of the company, the complaints should be taken to the legislature and not to the courts. This was a good ruling, establishing precedent for a lot of things that were coming later. Civil rights cases of 1883. These were 5 consolidated cases challenging the Civil Rights Act of 1875, which was a really good law. That prohibited racial discrimination in public accommodation like hotels, restaurants, and transportation. In an 8-1 decision, the Supreme Court interpreted the 14th Amendment so narrowly that it struck down the act, arguing that it could not regulate private business. This decision effectively ushered in the Jim Crow era of legalized racial segregation. It would take over 80 years for the court to switch course, allowing for the government protection of civil rights in the heart of Atlanta Motel versus the U.S., this time under the Commerce Clause. Altogether, the Jim Crow era lasts approximately 100 years. And it was a very bad decision. While not as bad as Dred Scott, it was a very bad decision for the American people. Plessy versus Ferguson, 1896. Jim Crow laws are constitutional under the doctrine of separate but equal. Police arrested Homer Plessy for refusing to leave a railroad car that prohibited colored people. Under Louisiana law, Plessy was considered colored because he was 1/8 black. The court ruled that the race-based Jim Crow laws did not violate the Constitution as long as the states proffered separate but equal treatment. The Constitution is colorblind and neither knows nor tolerates classes among citizens, Justice John Marshall Harlan said from the lone dissenting opinion in Plessy versus Ferguson. John Marshall Harlan was one of the great justices of the Supreme Court over all time. This, while again not as bad as Dred Scott, is certainly one of the worst cases by far the Supreme Court ever rules on. The decision upheld racial segregation under the separate but equal doctrine. This flawed logic, despite supposedly guaranteeing equal facilities for both races, inherently implied black inferiority and violated the 14th Amendment's Equal Protection Clause. Plessy's legacy is one of perpetuating Jim Crow laws, psychological harm to black Americans, and impeding racial progress for decades. Only in 1954 did Brown versus the Board of Education finally overturn Plessy and dismantle its segregationist legacy, a stark reminder of the dangers of legalized discrimination and the ongoing fight for a truly just and equitable society. And there's a picture of John Marshall Harlan, one of the giants of all time in the Supreme Court. Again, really a terrible decision on the part of the Supreme Court. Lockney versus New York in 1905. The Constitution bars a state from interfering with an employee's right to contract with an employer. Supreme Court struck down a New York limiting bakery hours to 10 hours a day, finding an implicit liberty of contract in the due process clause. In other words, if you really wanted to work 16 hours a day, you could contract with the person hiring you for that. The court struck down the law saying the 14th Amendment due process clause barred states from regulating commerce in this manner. Individuals have a fundamental right to contract with their employers, and states cannot interfere with that right. Later, though overruled, essentially, its legacy sparks ongoing discussions about balanced economic liberty with worker protection, interpreting fundamental rights, and the court's cautious power to influence public policy in a changing society. Bad decision. Again, one of the worst ever. Schenck versus the United States. Speech that presents a clear and present danger to the security of the United States is in violation of the principle of free speech as protected by the First Amendment to the Constitution. And this one is both good and bad. First of all, clear and present danger had to be ruled upon. But the fact that we have an espionage law in the first place is a bad thing. During World War I, Charles Schenck, the General Secretary of the Socialist Party, was arrested for distributing literature discouraging young men from enlisting in the armed forces. He opposed the draft or enlistment using the first clause of the 13th Amendment, which prohibited slavery or involuntary servitude to appeal. Justice Oliver Wendell Holmes stated that the character of every act depends upon the circumstances in which it is done. He also famously said, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words used are used in such circumstances and are of such nature to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Distributing the literature during peacetime would have been an entirely different matter. But in time of war, Schenck's actions, according to the court, presented a clear and present danger to the security of the United States. And so, as I said, it is a good ruling, but at the same time, it is a bad ruling because the espionage law should probably never have been written. Abrams versus the United States. In New York, 5 Russian anti-war activists were arrested under the 1917 Espionage Act for printing and distributing 5,000 leaflets that criticized the U.S.'s role in World War I. They also advocated for a general strike and had put out a call of arms if the U.S. intervened in Russia, which we were considering at that time when the Russian Revolution was unfolding. They were sentenced to prison for up to 20 years and they appealed. The Supreme Court held 7-2 that the Espionage Act was valid and it was a crime to willfully publish disloyal language about U.S. politics, arguing that such speech was not protected by the First Amendment, and the Espionage Act is still on the books, though actually rarely used. One of the most important things to come out of this case is Justice Holmes' dissenting opinion. He argued that the government should only regulate people's expression when it was required to save the country. Generally a bad decision. Although I will note that in this case, Oliver Wendell Holmes was demonstrating that he was also one of the great justices, although in one of the next cases, we'll find out he erred, I believe. Buck versus Bell. A young woman named Carrie Buck was diagnosed with feeble-mindedness and committed to a state institution, and after she was raped by her foster parents' nephew and had his child. Her mother had also been diagnosed as feeble-minded under the 1924 Virginia Eugenical Sterilization Act, and she was to be sterilized against her will since she was seen as unfit to procreate. Buck's appointed guardian sued, hoping to have the Supreme Court find sterilization constitutional. The Supreme Court held at 8-1 that there was nothing in the 8th or 14th Amendment that said Carrie Buck could not be sterilized. Bad decision. Eugenics, yes. The court declared in this terrible decision, the 8-1 decision written by Justice Oliver Wendell Holmes, the court upheld the forced sterilization of those with intellectual disabilities for the protection of the health of the state. Holmes ruled that, quote, society can prevent those who are manifestly unfit from continuing their kind, close quote, and ended the opinion by declaring that, quote, 3 generations of imbeciles are enough. Buck versus Bell was actually never overturned, at least not formally. Later cases shifted to individuals' fundamental right to procreate, undermining the eugenics argument and leading to the practice's decline. Thank goodness. Though it remains on the books, its authority is severely weakened and is no longer considered good law. It is a bad decision on the part of the Supreme Court. Justice Oliver Wendell Holmes wrote, "It is better for all the world if instead of waiting to execute degenerate offspring for crime or let them starve for the imbecility, society can prevent those who are manifestly unfit from breeding their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting fallopian tubes. 3 generations of imbeciles are enough." After this case, sterilizations did not cease until the 1960s, and more than 60,000 people were sterilized without their consent. The case has never been overturned. A very bad case. Here versus Minnesota. The 1925 Public Nuisance Bill, also known as the Minnesota Gag Law, allowed judges to close down newspapers that were deemed obscene or slanderous. In 1927, the Saturday Press, a newspaper based in Minneapolis, began to publish articles attacking several public officials. One of them accused a politician, the governor of the state, named Floyd B. Olson, of being a pawn to conspiracy. Olson filed a complaint. A judge, using the 1925 law, issued a temporary restraining order against the newspaper. The newspaper appealed under the First Amendment right to a free press, and this was a good decision on the part of the Supreme Court. The liberty of the press is safeguarded from invasion by state action. Although the First Amendment ensures a free press until this case, Neer versus Minnesota in 1931, it only protected the press from federal laws, not state laws. Minnesota shut down J.M. Neer's Saturday Press for publishing various anti-Semitic and racist remarks. In this landmark free press decision, the court ruled 5-4 that a state cannot engage in prior restraint. That is, with rare exceptions, it cannot stop a person from publishing or expressing a thought. The case stopped journalists from being censored and enabled the press to fulfill its role as watchdog, including the printing of the Pentagon Papers in 1971. A good decision. West Coast Hotel versus Parrish in 1937, a decision by the Supreme Court upholding the constitutionality of state minimum wage legislation. The court's decision overturned an earlier holding in 1923 and is generally regarded as having ended the Lochner era. Remember, I mentioned that a little bit ago as a bad case, a period in American legal history during which the Supreme Court tended to invalidate legislation aimed at regulating business. And so this was a good decision. But part of it is because it had an impact on the court packing scheme of 1937. It's called the switch in time that saved 9. FDR railed against the court's holding in the Lochner era. He hated it. This court struck down New Deal laws designed to pull the country out of the Depression on grounds that they interfered with a worker's, in quotes, right to contract. Remember, I said somebody could contract if they wanted to for a 16, 18-hour day if they wanted to, under the Lochner ruling. FDR pledged to expand the court and pack it with pro-New Deal members. His formula would have been there would be one new justice for each sitting justice serving over the age of 70, up to a total of 15 justices. The switch in the West Coast Hotel versus Parrish ruling undermined the proposal, and it failed. And so this was a bad thing for Roosevelt to try to do, but it was good that it got stalled. And so it was both good and bad that this was happening. Now, what happened is, as the Supreme Court was aging, some of them stepped down or died. In the next couple of years, Roosevelt was able to name justices so he could have more favorable rulings about his New Deal programs. Korematsu versus the United States in 1944. The Supreme Court upheld the internment of Japanese Americans during World War II, finding that the need to protect against espionage outweighed the individual's rights of American citizens. Technically, Korematsu has never been overturned by the Supreme Court. However, its legitimacy has been severely undermined and it is no longer considered good law. In 1983, a federal court judge overturned Korematsu's original conviction, acknowledging government suppression of evidence and racial prejudice. In 2018, Chief Justice Roberts strongly rebuked the Korematsu decision in the Trump versus Hawaii case, calling it gravely wrong and stating it has no place in law under the Constitution. Korematsu has lost its practical authority and is highly unlikely to ever be used as a precedent in future cases due to its discredited foundation and inconsistent theory and history. Bad, bad, bad ruling. Now we come to Brown versus the Board of Education, 1954. In the 1950s, Linda Brown, she was in Nebraska, had to take a dangerous route to school because the only school that was closer was for white students. Her father, Oliver Brown, believed this was a breach of the 14th Amendment, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws. Brown, along with a dozen other parents, challenged the segregation policy on behalf of their 20 children. And so this, undoubtedly, is one of the very best rulings of the U.S. Supreme Court ever. The decision, the Supreme Court unanimously held, and that's important, it was unanimous, that separate educational facilities were inherently unequal. A second decision called for lower courts and school boards to proceed with desegregation. Now, let me note that this is going to take 10 years before any of this really happens. The decision knocked down the doctrine of separate but equal from Plessy versus Ferguson, which had allowed mixed-race schools, transportation, and facilities to exist as long as they were equal. The Atlantic described Chief Justice Earl Warren's ringing opinion as the belated mid-course correction that began America's transformation into a truly multiracial world nation. And while it began there, it's not done yet. A good decision. The unanimous decision marked the beginning of the end of separate but equal that started with Plessy and the start of a new period of American race relations. With Brown, desegregation of public schools began, as did massive resistance to it. 10 contentious years later, 10 years later, the Civil Rights Act of 1964 made racial equality a matter of federal law. And very good ruling. App versus Ohio, 1961. Evidence illegally obtained by the state may not be used against a defendant in court. Until MAP, only the federal government was barred from using illegally obtained evidence. So when police entered Dolly Mapp's home without a search warrant and arrested her for possessing obscene books, her conviction initially stood. The court overturned her conviction, however, and extended the constitutional rule to apply to the states and their subdivision. A good ruling, a very good ruling. Baker versus Carr in 1962, one person, one vote. The above phrase was not authored until a year after Baker, but has its philosophical roots here. A group of Tennessee voters sued the state, claiming its voting districts diluted their political power. Until this point, the court refused to decide this kind of case, leaving such political questions to the states. Baker, however, held that the states must meet a constitutional standard for apportionment or appointment. Districts cannot be drawn in such a way that they violate the Equal Protection Clause of the 14th Amendment. A good ruling on the part of the Supreme Court. Engel versus Vitale in 1962. 1962, public institutions, a school system, cannot require prayer. Lawrence Roth, an avowed atheist, objected that his Long Island, New York school system was forcing his 2 children to recite a 22-word prayer at the beginning of the day. The court ruled that although the prayer was non-sectarian and non-compulsory, it is no part of the business of government to compose official prayers. Because New York provided the prayer, it indirectly approved religion and therefore was unconstitutional. A good decision on the part of the Supreme Court. Gideon versus Wainwright, 1963. Defendants in criminal cases have an absolute right to counsel. Too poor to afford a lawyer, Clarence Earl Gideon was convicted for breaking into a pool room, a felony crime in Florida. He appealed to the Supreme Court, which ruled that the government must provide free counsel to accused criminals who cannot pay for it themselves. At first, the ruling applied to felonies only. It was later extended to cover any cases where the penalty was 6 months imprisonment or longer. We have the Heart of Atlanta Motel versus the U.S. in 1964. The Heart of Atlanta Motel in Georgia refused to provide accommodations for black people. The Civil Rights Act of 1964 banned the practice. 2 hours after the act was passed, the motel asked the court to stop enforcement of a clause in Title II, which forbid racial discrimination by public accommodation providers. The motel argued that it exceeded Congress's power. So this becomes a good decision on the part of the Supreme Court. The Supreme Court held unanimously that the act was not exceeding Congress's power. It reasoned that discrimination by businesses had a big impact on black people traveling, even when it was a small business, since negative effects could be far-reaching when added up. It was especially the case here since 75% of the guests staying at the hotel came from out of state. This was the first case to challenge the Civil Rights Act, and by upholding it, the act was legitimized and strengthened. This law would go on to be used to dismantle many other forms of racist discrimination. Very good decision. New York Times versus Sullivan. To win a libel case, public figures must prove actual malice on the part of the writer. In 1964, the Times published an ad critical of an elected commissioner of an Alabama city. The commissioner sued for libel and won. The Supreme Court overturned that ruling and said that to ensure uninhibited, robust, and wide-open debate from public figures, the law must protect writers from libel suits. Thus, unless the words are penned with knowing falsity or reckless disregard for the truth, a writer cannot be successfully sued by a public figure for libel. A good decision for us who are the consumers of news in this country. Griswold versus Connecticut. The Constitution implies a right to privacy in matters of contraception between married people. Estelle Griswold, the director of a Planned Parenthood clinic, broke an 1879 Connecticut law banning contraception. The court struck down the law, making it a landmark case in which the court read the Constitution to protect individual privacy. This was to be the foundation of further privacy rulings, including the right to privacy in matters of abortion. But then we have the case of last year that I'm going to mention a little while why this becomes complicated. This was a good ruling, Griswold versus Connecticut. Miranda versus Arizona. In 1963, police obtained a written confession from Ernesto Miranda that he said he had kidnapped and raped a woman. However, they had not advised Miranda of his right to have an attorney present during the interrogation. Miranda appealed on the basis that his confession had been gained unconstitutionally. The Supreme Court held 5-4 that law enforcement must advise suspects of their Fifth Amendment right against self-incrimination right, to remain silent, their right to an attorney, and that anything they say can and will be used against them in a court of law. Very good decision for us in the United States over time. Evidence could not be used in a trial unless the warnings had been given and knowingly waived. Police work and the well-known "you have the right to remain silent" would not be so firmly entrenched into society or TV shows and movies without this decision. People know their rights, and police know they have to read them to suspects. Good decision. Loving versus Virginia, 1967. Mildred Jeter, a black woman, and Richard Loving, a white man, were from Virginia, where interracial marriage was illegal. In 1958, they got married in D.C. and then returned home. On their return, they were charged with breaking the law and sentenced to 1 year in prison. A judge suspended their sentence as long as they didn't return to the state for 25 years. Loving wrote to then Attorney General Robert Kennedy and asked for his help, and he referred them to the ACLU, which helped them sue. Good decision. In a unanimous decision, the Supreme Court held that the law was unconstitutional under the 14th Amendment. Chief Justice Warren wrote, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." In a watershed moment for civil rights, the case found that people of any race, anywhere in the U.S., could get married, striking down laws banning interracial marriage that still existed in 16 states. The case was later cited in same-sex marriage cases and was an important predecessor of those cases. A good ruling. Terry versus Ohio. In 1963, three men were suspiciously walking back and forth in a block in Cleveland, Ohio, and a detective thought they were preparing to rob a store. He approached them, identified himself, then frisked them and found two concealed guns. One of the men was convicted for having the gun. The man appealed. The issue was whether police frisking violated the Fourth Amendment. The Supreme Court held 8-1 that the search was reasonable, since the men were acting suspiciously, warranting inquiry. If circumstances justify a belief that an individual is armed and dangerous, the justices ruled the officer may pat down the outside of an individual's clothing. Good ruling. But there was a dissent. Justice William O. Douglas, the lone dissenter, did not think the standard for search and seizures should have been lowered from probable cause to reasonable suspicion. He wrote that yet if the individual is no longer to be sovereign, if the police can pick him up whenever they do not like the cut of his jib, if they can seize and search him in their discretion, we enter a new regime. The decision to enter it should be made only after a full debate by the people of this country. The case opened up the police's ability to investigate activity and seemed suspicious. His dissent, I do not think, was a good one. It was a well-written, but it wasn't a good action. Reasonable suspicion, just to clarify, is a lower standard than probable cause. It means that a police officer has specific, articulatable facts that lead them to believe a crime may be afoot. This standard is used for brief detentions and searches for weapons. Probable cause, on the other hand, is a higher standard. It means that there is a reasonable basis for believing that a crime has been or is being committed, and it is enough for a search or arrest warrant. Probable cause can also justify an arrest if a crime is witnessed by a police officer. I do not think his dissent was useful. Tinker versus Des Moines in 1969. School dress codes are not in violation of the First Amendment's guarantee of the freedom of expression. The Des Moines public school system made a rule stating that any student wearing an armband would be asked to remove it on the grounds that the wearing of such would be causing a disturbance. If the student refused to comply, the consequence was suspension from school. 3 public school students wore black armbands to express their opposition to the United States involvement in the Vietnam War. They refused to remove the armbands and were suspended. The parents of the students argued that the students' actions were not interfering with the rights of other students. This was a useful and a good ruling on the part of the Supreme Court. The court ruled that the wearing of armbands was closely akin to pure speech, and this was protected by the First Amendment to the Constitution. The ruling banning armbands lacked the proper justification for enforcement. This ruling eventually had an effect on school dress codes in that the style of clothing one wears indicates an expression of that individual. The ruling is generally considered a good one as it protects students' freedom of speech and expression, allowing them to engage in symbolic protests such as wearing armbands, unless the school can demonstrate that the speech would cause substantial disruption or invade the rights of others. The decision in Tinker versus Des Moines has been influential in shaping the legal landscape surrounding student rights and free speech in the United States ever since. A good decision. Brandenburg versus Ohio, 1969. Clarence Brandenburg was arrested after making racist remarks and claiming the government was suppressing the Caucasian race to a gathering of Ku Klux Klan members in a field in Ohio. He also mentioned action might need to be taken and was filmed by media he had invited to the gathering. The state law criminalized advocating violence as a means of accomplishing political reform, and he was sentenced to 10 years in prison. The issue was whether free speech advocating for violence was protected by the First Amendment. And a good ruling, because the Supreme Court held per curiam. Per curiam means in the name of the court rather than the judges. His freedom, they ruled that his freedom of speech had been violated. It found that speech may only be outlawed when it is directly inciting imminent lawless action. It also found that abstract discussions are not the same as actual preparation to engage in violence. The case broadened protections for political dissent. Good. San Antonio Independent School District versus Rodriguez. The Constitution does not guarantee a fundamental right to education. It's not mentioned in the Constitution. In 1968, a group of low-income parents from San Antonio claimed the city's wealthy precincts had better schools. Much of this financing of schools was based on property tax, and of course, more wealthy neighborhoods and businesses paid a different level of taxes, and so it was unequal. The court upheld the districting plan, saying that the Constitution did not guarantee an education. In upholding this tenet, the Constitution does not compel government to provide services like education or welfare to the people. Rather, it places boundaries on government action. Even though unequal across a state, are local property taxes unconstitutional? The answer in this case was yes, but it's both a good and a bad ruling. Roe versus Wade, 1973, one of the most important cases ever. The constitutionality implied right to privacy protects a woman's choice in matters of abortion. Norma McCorvey sought an abortion in Texas, but was denied under state law. The court struck down the law on grounds that it was unconstitutionally restricted the woman's right to choose. The 7-2 opinion set forth guidelines for state abortion regulations. States could restrict the woman's right to choose only in the latter stages of the pregnancy. Later somewhat modified but not overruled until last year in Dobbs. The decision stands as one of the court's most controversial. I believe, of course, it was a good decision. States versus Nixon, 1974. The case was triggered by the Watergate scandal when a special prosecutor asked for tapes that President Richard Nixon had recorded in the White House. He refused, saying he had executive privilege that allowed him to withhold sensitive information in order to maintain confidential communications and to maintain national security. Nixon released edited versions, but not the complete tapes, leading to Nixon and the prosecutor both filing petitions to be heard in the Supreme Court. This was going to be a good decision by the Supreme Court. Neither separation of powers nor the need for confidentiality can sustain unqualified presidential immunity from the judicial process. So now the question of immunity for a president is before the Supreme Court again in a different context. What impact will this ruling have on that debate that the Supreme Court is having? We don't know yet. President Nixon sought precisely this type of immunity rather than relinquishing the famous White House tapes during the Watergate scandal. The court unanimously rejected his plea as an unconstitutional power play. The House began impeachment proceedings shortly thereafter, and 2 weeks after the ruling, Nixon resigned. Harvard constitutional law professor Lawrence Tribe said, "Not even the president is above the law." Let us hope that that remains the case. Regents of the University of California versus Bakke. Alan Bakke, a 35-year-old Vietnam War veteran, was rejected from the medical school at the University of California twice. Every year, the school accepted 100 people, and 16 of those accepted were from minority groups. He argued his rejections were due to reverse racism, since his grades were better than the 16 people who got in on minority seats. Supreme Court held 5-4 that Bakke should be admitted. However, it also said race could be taken into account to promote diversity on campuses. 6 different justices wrote opinions, which is unusual. In one opinion, Justice Harry Blackmun wrote, "In order to get beyond racism, we must first take into account of race. There is no other way, and in order to treat some persons equally, we must treat them differently." Since this case, despite affirming that race could be taken into account, the percentage of black freshmen in the U.S. has not changed. A recent analysis in 2017 found that they make up 6% of freshmen, but 15% of college-age Americans. A good ruling. Bowers versus Hardwick. This decision upheld a discriminatory Georgia sodomy statute that criminalized sexually active gay and lesbian relationships. Justice Harry Blackmun noted in his dissent, the majority opinion displayed an almost obsessive focus on homosexual activity. The decision was inconsistent with precedent because it denied a fundamental right to privacy for consenting adults, established in other rulings, engaging in private sexual conduct, even though the court had previously recognized privacy rights in cases. It was inconsistent and a very bad ruling on the part of the Supreme Court. It invoked the slippery slope argument, suggesting that recognizing a right to homosexual sodomy would lead to the legalization of other immoral acts, which later proved unfounded. All of this left many wondering where the line would be drawn between permissible and non-permissible private acts. The majority opinion also relied on outdated notions of morality and failed to provide a compelling legal basis for criminalizing private consensual acts. In his essence, Bowers was overruled in 2003 by another case, Lawrence v. Texas, that I'll talk about in a moment, which recognized a fundamental right to privacy for all consenting adults engaging in private sexual conduct regardless of their sexual orientation. This was a major victory for LGBT plus rights and helped pave the way for future advancements, including marriage equality. But Bowers versus Hardwick was a very bad decision. Lawrence versus Texas. Police entered a private residence on a false report about a weapons disturbance and found Lawrence and Garner engaged in a consensual sexual act. They were arrested and convicted under Texas law, which forbid two people of the same sex to have sex. The issue for this case was whether the 14th Amendment protected them. The Supreme Court held 6-3 that the Texas law violated their right to liberty under the Due Process Clause, which allowed them to engage in their conduct without government intervention. This was seen as a victory for LGBT plus rights, removing what one law professor called the reflexive assumption of gay people's inferiority and overturning 14 state laws across the U.S. Very, very, very good decision. Versus Johnson, the Constitution protects desecration of the flag as a form of symbolic speech. Johnson burned a flag in front of a Dallas building in 1984. He was convicted of violating a Texas law that made it a crime to intentionally desecrate a state or national flag. Justice Brennan wrote for a 5-4 majority that government may not prohibit the expression of an idea because society finds the idea itself offensive or disagreeable. A good decision. Cruzan versus Missouri, Department of Health. While the Constitution protects a person's right to reject life-preserving medical treatment, in other words, you do have a right to die if you make a conscious decision and are of good mind. States can regulate that interest if the regulation is reasonable. Nancy Cruzan lay in a permanent vegetative state as a result of injuries suffered in an auto accident. Her parents sought to withdraw life-sustaining treatment and allow her to die, claiming she'd said this would be her wish under such circumstances. But it was not anything that she was actually being quoted as saying. The state refused, and the Supreme Court upheld the state's guidelines for the continuation of medical treatment, which allowed withdrawal or treatment only with clear and convincing evidence that this is what the patient would have wanted. And this is why we should always do this in advance, so that we have expressed our wishes. The court said that given the need to protect against abuses of such situations, the state can continue life support as long as its standards for doing so are reasonable. I don't think this was a good decision. Bush versus Gore, 2000, shaping the outcome of the 2000 presidential election, one of the most controversial Supreme Court decisions in American history. The razor-thin margin by which George Bush won, along with discrepancies in Blount County in Florida and concerns about hanging chads, remember that? Raised allegations of voter disenfranchisement and fueled accusations of unfairness. The Supreme Court's intervention in the election process was highly unusual and unprecedented, raising concerns about judicial overreach and undermining the public's confidence in the democratic process. Furthermore, the 5-4 decision along ideological lines with conservative justices siding with Bush and liberal justices supporting Gore ignited partisan tensions and accusations of political bias. Very bad decision. It amplified the controversy and deepened the public divide. The Republican majority stopped the recount, raising potential violations of the 14th Amendment's Equal Protection Clause and arguing that different standards for counting votes across counties could unfairly disenfranchise voters. However, critics argued that stopping the recounts altogether disproportionately affected Gore's supporters in those counties. This decision, of course, has never been overturned. Its aftermath potentially set a precedent for future involvement of the Supreme Court in close elections. The equal protection holding in Bush v. Gore has never been cited as a precedent, and the majority opinion specifically warned in the decision that our consideration is limited to the present circumstances, discouraging future courts from relying on any legal holding in the decision. Very bad for America. District of Columbia versus Heller, 2008. Richard Heller, a security guard who lived in D.C. and carried a gun for work, was not allowed to have a gun at home due to the city's laws. He thought the laws were too restricting and made it impossible to defend himself. Heller, along with 5 others, sued, arguing it was a violation of the Second Amendment. They were funded by Robert Levy, a libertarian lawyer. The Supreme Court held 5-4 that the Second Amendment guaranteed an individual's right to possess a firearm at home for self-defense. It was the first time in 70 years the Supreme Court ruled on the Second Amendment. In 2019, former Justice John Paul Stevens said it was the worst decision during his 34-year tenure, representing the worst self-inflicted wound in the court's history. He said an amendment should be added to the Constitution to overrule the case to stop gun massacres like that later would happen in Las Vegas or San Diego. Bad decision. Citizens United versus FEC, a recent case about presidential elections. It's a household name to this day due to the ongoing controversy. It held that political donations are speech protected by the First Amendment, opening the floodgates to unlimited personal and corporate donations to super PACs. Critics argue that this grants enormous influence to wealthy special interests and corporations, effectively drowning out the voices of everyday citizens and giving undue power to a select few. Supporters argue it's a victory for free speech, protecting the rights of corporations and individuals to express their political views. They see limitations on campaign spending as censorship and believe increased money in politics doesn't necessarily lead to corruption. Critics counter that free speech shouldn't translate to unfettered financial influence in elections, arguing it undermines the democratic principles and fair representation. The effects are still unfolding, but it has already contributed to increased polarization in American politics, and we are highly polarized in our political view today. A focus on fundraising over policy discussions and growing public distrust in democratic institutions is the result. Bad decision. Obergefell versus Hodges in 2015. James Obergefell and John Arthur, a couple from Ohio, got married in Maryland. In Ohio, same-sex marriage was not allowed on death certificates. Arthur was chronically ill and wanted to have Obergefell on his death certificate. Along with 3 couples from Kentucky, Michigan, and Tennessee, they sued their states, claiming they were in breach of Equal Protection Clause of the 14th Amendment, which says no state shall deny to any citizen within its jurisdiction the equal protection of the laws. The Supreme Court held 5-4 that the 14th Amendment guarantees the right to marry, including same-sex marriages. Every state in the U.S. now legally recognizes same-sex marriage. Before this case, 13 states still had a ban on gay marriage. We think this was an excellent case. I have to mention the Respect for Marriage Act in 2022. There was a consequence of this because of the threat that it could be overturned on an increasingly conservative court. The Respect for Marriage Act 2022 provides statutory authority for same-sex and interracial marriages. Specifically, the Act replaces provisions that define, for purposes of federal law, marriages between a man and a woman and a spouse as a person of the opposite sex with provisions that recognize any marriage between two individuals that is valid under state law. The act also replaces provisions that do not require states to recognize same-sex marriages from other states with provisions that prohibit the denial of full faith and credit or any right or claim relating to out-of-state marriages on the basis of sex, race, ethnicity, or national origin. Now, what they did put in is some restrictions as to its application in terms of religious liberties and religious organizations, and it also limited it to a marriage between two people, so you couldn't have three-person marriages and so forth. But on the whole, it is a very, very, very good act and clarified the ruling of the Supreme Court in Burgeville. Dobbs versus Jackson's Women's Health Organization. In March 2018, the Jackson Women's Health Organization, Mississippi's only abortion clinic since 2006, sued the state for enacting a law that banned abortions after 15 weeks of pregnancy. The lawsuit argued that the rule was unconstitutional due to the precedent set by the Supreme Court, including Roe v. Wade, Planned Parenthood versus Casey. The Supreme Court held 6-3 to uphold the Mississippi law. However, on top of the ruling, 5 of the justices in the majority opinion also ruled to overturn Roe, repealing a landmark case that made abortion legal in the U.S. for nearly 5 decades. Chief Justice John Roberts was the only member of the court's conservative majority who believed the court should not have outright overruled Roe. So this, from my point of view at least, is one of the worst decisions on the part of the Supreme Court, and we're not done with this yet because it's going to be the major campaign issue of 2024. And so that is the end. And what have we established in taking a look at the Supreme Court's rulings over 248 years? We've established that the court is fallible, that they make mistakes, sometimes gigantic mistakes. We also have to concede that on the whole, they have preserved and protected our precious Constitution. And so the rule of law does prevail. So now I want you, as we are ending here, to remember to hit the subscribe and like buttons so I can be encouraged to create more History by Lou just for you. And I thank you for tuning in, and I hope you have a good day, a good week, a good month, a good year, and a good life. I would really appreciate it if you would hit the subscribe and the like buttons down below, because that gives me an incentive to produce more programs just for you.